environmental audit now. Please, sir.
You should have asked me now what is new in the morning. I would have said this.
Alright, so sir, what is new in the morning?
Learning how to link Gita with safety.
Wow. So sir, learn how to link Gita with safety.
Thank you so much.
You're welcome, sir.
Yeah.
No.
Is it good? Thank you so much. First of all, yeah, Sanjaya. Yeah, thank you so much for the introduction. And Miss Nisa Swami, congratulations for this first honors. You have named it first. So first step, anything, everything first. It may be first who created the parliament, first who landed on the moon, and first who got the awards here. So everywhere there is a kind of imprint in the history. It will be a history. So you have taken the first step. So congratulations for that. Now after such a you are going to listen me with some legal terms, legal, and I'm hardcore. I have to always look into what is wrong, what I can counter, what is the point, what are the evidences which I can counter so that I can fight for my client, right? So those things, and of course it is a notification already published. So I am going to share about that notification. New environmental audit framework, implications, compliance duties, and of course corporate liabilities. Audit is not a new thing for us, at least not for the professionals here. Audit comes from a Latin word, audire, to hear. And hearing is the most difficult thing, I think. So when it comes to, for a legal professional like me, when it comes here or hearing, it straight goes to courtroom hearing, or maybe some magistrate hearing, or maybe even it may be something like giving a hearing to your SPCB, Ministry of Environment, kind of things. But here this hearing came from a financial hearing. The owner gives a hearing to the accounts person probably, and the accounts person is going to say that this was the budget and this is the actual income and expenditure. So from there audit started, and on the left side you can see our also in India Kautilya's Arthashastra reflects audit. This much, of course, from the historical aspect, otherwise other things are completely into environment. Now, how environment audit came into India? In 1992, March 1992 it came, 2 years earlier than EIA notification. 2 years earlier than EIA notification came on probably 27th January 1994. And today, if you ask anybody, who knows or understands the environment, will understand EIA, but they will not understand environment clearance. EIA they will understand, but they will not understand much about environment audit. Anyway, 1993 there was a little amendment, and it was called as environmental statement instead of environmental audit report. And most of you must be knowing that environment audit or environment statement we submit on 30th September, and it was aligned with the financial audit report. So the 30th September date was there, and the term was called environmental statement. After so many years, around 32 years, after 32 years almost, now we have got a different one. Now why the different one? So 29th August it was published, the final one. Earlier there was a draft notification, and it was published finally on 29th August 2025. Now why this change? Probably our over-reliance. We were more reliant on post-violation enforcement. Like, you jump a traffic post red light, and the police will catch you. The police will not stop you beforehand so that you don't violate. So what we were doing, maybe the SPCBs, maybe the ministry, or maybe anybody, whosoever is regulating your environmental aspects, they were trying to do more into, you can say, polluter pays principle, right? But now the change is coming with a lot of inputs, like you have climate finance now, you have got green credit rules, you have got the emissions trading again coming back into picture, EPR, the extended producer responsibility, all those things when they have evolved. So there was a need to change the environmental audit system also. And what it focuses on? It focuses on the precautionary principle. Your precaution, so that you don't do the violation, you don't do the non-compliances. Violation is a different thing. Non-compliance even you don't do, and you identify those earlier so that you focus on your business, and you don't get into the legal or the penalty clauses. So this is the basic focus, what I understand from the notification. And there are some other points also. ESG and alignment. ESG has come. BRSR. Some of the industries are also submitting BRSR. The ESG is a common term, of course, nowadays. Environment, social, and governance. Now, another thing is that I have highlighted certain things. You can focus. I may not be speaking all entirely. Now, the current one, earlier one, what we were doing pre-2025, we were doing anybody from us, either we hire a consultant or we do it on our own. We can fill that Form V, and Form V is filled, signed, submitted. So that was self-audit, our self-certification. Now it is a mandatory third-party audit. Somebody has to come now, audit, and who will come? I'll tell you in subsequent slides. Now the focus shifts from self-reporting to disclosures, self-reporting disclosures to verified evidence-based audits, and there are certain aspects also, that's misreporting, and if we are not suppressing some data, some information, those are also in a specific penalty clause. So corporates or industries have to, or maybe anybody, any business enterprises which is coming under this under the audit rules, they have to cooperate, and they should not obstruct the audit, because the auditors may not be only the person or organization you are choosing. Somebody from outside, maybe CPCB, maybe SPCB, maybe the ministry, or maybe any other body can depute the EAD, may depute the auditor. So we will explore one by one. Now this is the audit statement. Before coming to this, I will talk about, there is a point, evidence based. Now evidence, I think sir told in a very lucid way about this Gita and this evidence, but I'll tell in a different way. Evidence is, there is a 7-star hotel in Gurgaon. Anybody from Gurgaon? Anyway, there is a 7-star hotel in Gurgaon. I don't know whether it could shape up, because the company which started, they sold it to somebody else. So now that hotel in 2006 there was a EIA notification. The EIA notification was amended, heavily amended. 2006 there was a court case, and the court case said that the construction company they violated the EIA notification, and construction company violated the EIA notification because the EIA notification, I think 7th July 2004, this EIA notification came for the construction companies. and every small construction was also falling under that. 50 crore there were three conditions. One was 50 crore. The land price is so much in Gurgaon, or maybe some cities like Bengaluru or Delhi. So in such a case, that there was a court case. Now they somehow came to us. They reached to us. That time I was not an advocate. So anyway, what we did, we tried to understand what is the scenario, and we came to know from the documentation that they had started some excavation, and excavation was started in January 2004. Notification was there, 7th July 2004. They started excavation in January 2004. We asked that, do you have some kind of documents related to, linking documents showing that, it supports your evidence. They somehow managed to find out a work order. They gave a work order, issued a work order to a contractor, and the contractor accepted that. Then there were two more supporting documents. One is a check payment. That time check was more prevalent, check payment. And then there was from the check payment we asked that, can you give us your bank statement? They gave us the bank statement. So there were four evidence, and all were linking. There was one RFQ, there was one quotation, then there was a PO work order, then there was a payment. So we submitted all those and we requested the ministry's office, and we said that they are not falling under this. They had started much before, around 6 months before that. So somehow ministry issues a letter, and it was submitted to the court. That time NGT was not there. The courts were running. There was one court in Faridabad. So the courts were running, environmental courts. So they finally they were out of this. So evidence works a lot. There are tons of examples where how you can create your evidences, protect your evidences, and the evidence will actually protect you again. This is the definition. This is the definition of the new notification. New notification environment audit is defined like this. Four things, or three things rather I should say. One is verification, one is examination, inspection. All these terms are very, anybody who is involved in audit is aware about these terms. But verification, I am saying, please note or link it to the green credit rules. Green credit rule has a deeper link with this verification. Now, the architecture, what is the system basically? What is the system of the environment audit? It is a mandatory third-party audit. Then, a registered environment auditor. The 2J, if you see, it is the definition given in the rule, the Environment Audit Rule 2025. If you go to section 2J, there is a definition. Now, registered auditor will be different from a certified auditor. Registered auditor is probably for some time, because the agency is not so far constituted. Once the ministry constitutes the agency, then probably the registered auditor will be a different subject, and they will more focus on the certified environment auditors. Registered auditors will be created with the help of experience, with the experience and expertise for some time till they certify auditors, because certification processes will be based on trainings, as well as there will be some national level tests. So accordingly, and certified auditors will be minimum 2. It has to be an identity, maybe a private limited or maybe limited or some kind of even maybe partnership, but at least there will be 2 auditors. So after that body, but for the time being, registered environment auditors. So that they have to come, and they means one has to come and audit. And it will be randomized allocation. Randomized allocation, as I said, it is not necessarily that you picked somebody. It may be allowed, but at some point of time, the authorities may also avail this rule, and they may depute for audit of your premises. And at that point of time, you have to facilitate everything for the audit. Then the audit outcomes will be linked to. Now, so far, if you look at it, whatever good things you do, nobody appreciates. But if you do something wrong, if there is a failure in the let's say your OCEMS, and the data is not going to the server of the CPCB, you will get a so much notice, despite the fact that you are maintaining everything in a fantastic way. But you will get a so much notice, or maybe even penalty sometimes. Now, if you are doing something good and you can prove it, it is audited, then it can be linked to green credit. Green credit rules 2023. So that is one. Green credit rules, I think everybody must be knowing, because if you do something demonstrable, audited, and reducing the pollution, or if you are afforestation will also come here, because let's say small industries or big industries, small industries or medium scale industries may not have that afforestation aspect, but let's say project like NHI, which is planting a lot of trees, they also go for this environmental audit. Let's say bigger projects, which is massive scale, maybe city to city like. So in that case, the plantation, afforestation, that also comes into this audit aspect. Then your ESG disclosure, environment, safety and environment, social and governance, that disclosures will also come. Sometimes BRSR, that also, it is not for all, but BRSR also you can link this data. And of course, these things will add value to your financing, climate finance or maybe any other finance from the finances, government or private. These are to be covered under the audits. Earlier, forest and wildlife was not covered. Anything you give, you are more focused on, there were 5 pages and you can expand it to anything, but there were primarily 4-5 pages, and you have to fill in what is the water requirement, what is the water consumption per unit, what is the water pollution per production or maybe per square feet, something like that. Then your Air Act, EPA, Air Act, Water Act. Now the forest and wildlife clearances. Forest and wildlife clearances, why? Because this CAMPA, this compensatory afforestation of the that aspect will come. So that is there. CRZ notifications, waste management rules. It is no more small. Waste management rules now. Solid waste management rules. E-waste management rules, battery waste management rules. You have all the your plastic waste management rules. Everywhere where there is EPR, you are getting this benefit. So you have to get it audited, and if you are doing good job, then it has to be recorded so that you take the benefit. And what all the industry covered, infrastructure, maybe highway projects or construction projects, mining, power, large commercial projects. Now, because the CPCB or any authority is sending you an auditor, it doesn't mean that they will not come. They will still come. So these audit system will supplement, not replace the regulators. So even then, there may be audits by the SPCB also. So government audit will, in case let's say your auditor has given a report, and subsequently after that there is a body, maybe SPCB or any other body comes, and there is a conflict in the report. So which report will prevail? The government body's report will prevail. It is given in 16.2, Rule 16, Sub-Rule 2. And audit findings, be it your the REA or CEA or the government audit, any audit finding may trigger inspection. Subsequently, SPCB may come, MOEF may come. It may lead to any SOCUS notice. It may lead to closure proceedings and penalty proceedings. Penalty so far nowadays mostly penalty is an issue because environmental compensation has come into picture. So a lot of penalty proceedings are there. Now, what is the role of the auditor? Any auditors, REA or CEA, comes to the site, inspections. The auditor can draw samples for analysis and issue the reports, and both they can see your and collected your reports, existing reports. Verification of records, particularly verification records, always I am linking with the Green Credit Rules 2023, because it is linking to your finance. Then the identification and reporting violation non-compliances. When there is a non-compliance, the identification of non-compliance is very important. Non-compliance and violations are two different things always. Violation, let's say somebody is not having a CTO, environment clearance, that is a violation. But if you are doing something with the CTO and you are not complying the clauses, then it comes to non-compliance. So non-compliance and violations, two different things. And the impacts are also, if you talk about the legal impacts are also different in both the cases. Then of course the computation of the environmental compensation. Computation of environmental compensation now is given the responsibility to the auditor. This is a major thing, because everywhere you must have seen that it goes to the, either sometimes the entity does, but nowadays mostly an entity also relies on the SPCBs or the SPCBs. Basically they give it to SPCBs, and SPCBs whatever they want to do. So computation of the environmental compensation, and the report has to be submitted to the CPCB or the EADA. Code of conducts. This is something very important for the auditors, that you do not submit any kind of wrong or false data, misrepresentation of any data, suppression of data, concealment, distortion of facts. At the same time, the auditor has to maintain confidentiality, accuracy, and if there is a misconduct proven and it comes to the EADA, then there will be a suspension or debarment, because usually they are going to give for 5 years probably. That is what in the plan so far. Now the mechanism is given in Rule 7. Recognition, first of all, recognition will come, and recognition will be given by EADA. Then in the process there is one national certification examination which is going to happen. It has not happened, nothing has happened so far. It is going to happen. Period of validity of registration is expected to be 5 years, and even who is going to do that, that is also not clear so far probably. The EADA has to take all the call. Now, what is the role of the EADA? EADA is Environment Audit Designated Agency, and it is a body of the ministry. It is a body of the ministry. The definition is there in section 2F. Now, it will issue the certification of, it will certify the auditors. It will make the registration and public registry. It will maintain. Then prescribing norms of audits and how the evaluations will take place. How the certification will take place, monitoring performance of the auditors as well as the audit reports, and enforcing the code of conduct. Then the conflict of interest. This is one important thing. In fact, so far, anybody, let's say you have a company and you want to get the environment audit done from somebody, you can hire somebody, some consultant if you want. But the same consultant was doing the EIA, or it has prepared the environment management plan, or it was involved in the consent management. That is not going to happen here. If a consultant is there already, which is working for your consent management, waste management, or any kind of guidance, they will not be your auditor. Similarly, if somebody has prepared your EIA, EMP, somebody means the body corporate also. So EIA, EMP, they are also not going to be a part of they will not be an auditor. If there is any financial or relational interest, please note, If let's say somebody is related to the owners or maybe the board of directors, then there is also a bar. So auditors function quasi-regulatory, and though the enforcement authorities they have the major say. Corporate the duties of the corporates. You cannot say that this is exactly given somewhere in the rule, but you will find how it is linked in the rules. There is no specific rule giving the responsibility of the corporate, but you will find it in the process. So audit cooperation, actually no longer it is going to be voluntary. It has to be legally obliged. So you have to give full access to the auditor. You have to give your records, data, samples, whatever. Maintain internal environment control systems. Cooperate with the auditors. Randomly assigned auditors are always who are deputed by the authorities. Now there is a point. The rules elevate the environmental compliance from operational paperwork to a matter of governance responsibility, reputational integrity, and financial valuation. These 3 points. Now, governance responsibility. You must have heard about certain cases going on. Even now, it has landed up in the Supreme Court. Now, the cases are like the PCBs they are understaffed, and this was started probably in 2021, 2022. PCBs are understaffed. When it started, Madhya Pradesh was the most understaffed state. Madhya Pradesh MP PCB, but the matter started from Haryana. Somebody started from Haryana. And they were always telling that we are short of manpower, we cannot, we are taking time. Court process takes time. So they were telling that, we are short of manpower, So, and government, if you see, you must have seen in fact, the Ministry of Environment's regional offices, now they have opened so many regional offices, probably 19 or 20 regional offices. Anyway, there was an office of the ministry. The office is called Integrated Office. Earlier there were 6, I think, Chandigarh, Dehradun, and Shillong, Bhopal, South Bengaluru. So there was something somewhere. These 4-5 were there. Lucknow. But now there are 19 or 20, and even then they are not able to meet the guidelines set by the guidelines. I should not say, there is an order of the NGT that for large scale red category industries you have to go every 3 months. But have you seen anyone coming to your premises before 1 year from the ministry? I am talking about representing a ministry and coming to see the compliance level of your environment clearance. I have not seen, at least in many cases, that they are coming before sometimes when you are applying for some kind of expansion, EC for expansion, they don't come. So that governance responsibility, now they are offloading to whom? The auditor. They are saying that remove it from our shoulders, let it go to the auditor. Reputational integrity comes to the companies. So once you are doing good things, it is audited and it is published. So it goes to your ESG, it goes to your BRSR. So reputational integrity is there. And financial valuation, when it relates directly to your green credit or carbon credits, or maybe your finances, climate finances, and the green bond, other things. So that part it is going to. Now what the corporate must do, they must integrate audits into the compliance routines. Maybe, sir, I have to understand from Gita if I can find out something, but that's a good thing. Compliance routines, you have to focus more on the compliance routines. ESG strategy, ESG, when S comes, I'm happy to see that the honor is, the award is not only for environment, it is CSR, where society is coming, safety, which is Again, safety relates to entirely society, not only the industry or the company premises. Quality, again, it relates with the society. HR, many times, people, sometimes environment people say that HR is taking responsibility. What the specific, why not the people from environment? But HR has a greater role when it comes to society. Society as well as governance also. HR covers admin most of the time. When HR and admin are there, so society. So ESG strategy you have to redefine or maybe recalibrate. And the regulatory risk management. Regulatory risk management is like you have probably you are having some say one borewell or two borewells, and you require to have a NOC from the authorities. You have not taken 10 years or 20 years gone. Now regulatory risk is there, and if there is a risk, you never know how much will be the compensation figure. It starts going to crores even sometimes. Role of legal practitioners like me. When there will be an audit, these things, when there is transparency, when there is knowledge, you must be ready that there will be more litigations. So litigations help you. Litigation, disturbs you. But anyway, that is a part of the system. So environmental audits as litigation material. People like me may get more works from the corporates. Audit preparedness. When you prepare for the audit, you before the audit you can take help from legal practitioners how to go about safety, health, environment, ESG, and when audit outcomes. Once the outcome is ready and you understand that so many non-compliances there, how to manage those non-compliances, that can be probably given, guided by a legal practitioner. So this is the way. I think the strengths are the transparency, independence of the auditor, transparency of the audit process and the results, outcomes. Preventive orientation. Preventive because, why it is preventive? Because it is based on precautionary principle. And the concerns are capacity of the auditor. I am not saying that capacity of the auditor means, the auditor as a company or any auditor is going to have questionable. But sometimes what happens, there is a big hospital in the northern India. It was audited by a very huge company, very big audit company. And 2016, I remember, 2016 there was a change in notification of the hazardous waste management rules. So the notification came in April, and there was a filing of there is a form 4 annual return we submit, and that annual return was submitted on 30th June of that year. Now the auditors pointed out that notification came in April, so you should have followed this particular, form in place of form 13. You should have submitted form 10. I said, you give me the form 10. Is it possible? Because it relates to the previous financial year. So, auditor's capacity will depend on training and the people you are deploying, the company which is deploying the auditors. The capacity of those auditors, it will define the capacity of auditors. Uniformity of standards. Uniformity is very important because sometimes there is a standard given by the, let's say, NGT. There is a CB standard. When it comes to ministry, didn't bring out any standard, but state pollution control boards have taken the responsibility and they have devised standards. Standards were devised in 2019, standards were devised in 2021, 2023 also. Now, which standard has to be chosen? That has to be taken up. So that uniformity of standards, one has to study, one has to be aware about which standard has to be taken up, selected. And the risk of proceduralization. Now, this is something when the procedure is so much procedure is not going to be easy. It will take time for everybody, auditors as well as the auditee. So it will take a little bit of time, but the judicial oversight will shape operational controls with time, of course. Everything, with time, everything goes refined. Now the concluding, there are 2 slides. The new environmental audit framework is a substantive governance mechanism with direct legal consequences, posing board level risk for corporations. Board level risk is there because nowadays, we all know that it is the regime of environmental compensation. No more those, you go for that criminalization, criminal activity. That is no more there. Rules have been decriminalized now. But when it comes to heavy penalty, it is a board level discussion. Strengthening regulatory compliance and serving critical evidence. The evidence is most important. Tool shaping enforcement and environmental jurisprudence. So everybody is going to be, if you look at the national level, I'm sure with time the court cases will also reduce because compliance will be better. Nobody wants to remain non-compliant or violated. It is all that one has to understand. So that's all. Thank you very much again. I'm really delighted to get this opportunity to stand before such a mass, and thank you very much.
But I would like to call upon you on the stage again. So much knowledge.